So from the National Post, judge gave excessively light sentence to avert deportation of refugee who threatened to kill police. The case shows how judges weigh the severity of crimes by non-citizens against the consequences of jail time for those who could be deported. The Manitoba Court of Appeal has ruled a judge gave an excessively light sentence to a 23-year-old Somalian refugee to prevent him from being deported, after the man rammed his car into a police vehicle and threatened to kill the officers who arrested him. Now, for those of you who don't know, in Canada, this isn't even the first case this month that there has been something like this. Earlier in the news, there was a woman who was given a much lighter sentence than her fellow bank robbers to keep her from being deported back to her home country, more or less on the basis that she didn't have any family there, because her family came here and all became Canadian citizens, except for her. I haven't read through the whole article yet, so you're getting my sort of raw opinion on this as I first read it. So they might touch on that and they might not. The court ruling on October 31st had increased Mustafa Ahmed Yar's sentence to more than 13 months from 5 months and 25 days. In their decision, the judges found that the longer sentence may result in his deportation, but was necessary because the sentencing judge failed to impose a sentence that was proportionate to the gravity of the offense. The case sheds light on how judges weigh the severity of crimes committed by non-citizens against the consequences of jail time for those who could be deported, after Harper-era changes to immigration rules attempted to make it easier to remove criminals. And you know what, this is a problem. We are a nation of laws. We have these laws and rules. If you break them, you should go to prison, and if that results in your deportation because you're not a citizen, so be it. We shouldn't be giving lighter sentences to people because they're not Canadian citizens. It's just ridiculous. Okay, let's see more of the article. Yeah, he and his family moved to Canada in 2009, and he lived with his parents, according to the appeal court ruling. Okay, so here we go. Here's what happened. September 2017, he was arrested after he refused to pull over during a traffic stop, instead accelerating, ramming into the police car and causing it to stall. He then drove off at a high speed with other police cars chasing him, crashed into a metal signpost, and fled on foot. After he was arrested, according to the court decision, he told police officers, "I'm going to get my gang and I'm going to find you and kill you. I'm a real gangster and you will die. Trust me, you effing goofs." Less than 2 weeks after he was released on bail, he was arrested again while in breach of his curfew. According to the ruling, he was already on probation at the time of his arrest and has a lengthy and related criminal record. Okay, so why are we keeping him here? Clearly this person does not want to become part of a law-abiding society. Why would we be reducing his penalties because he would be deported? I mean, the penalties should be similar across the board, citizen or non-citizen. Non-citizens shouldn't be getting lighter sentences to keep them from being deported, and it doesn't sound like this is the kind of person we would want here anyway. Let's see, he pleaded guilty to charges including fleeing from police and uttering threats. During his sentence hearing, the judge found that he ought to be jailed for about a year for these charges, but ultimately decided on a much shorter sentence, 5 months and 25 days. A bit of background information. Permanent residents can lose their status and be deported from Canada if they're convicted of a crime with a possible jail sentence of 10 years or more, or sentenced to more than 6 months in prison. A sentence of 6 months or longer also strips them of their right to appeal deportation. I don't really see a problem with this. Why would we want to keep these people in the country? Knowing this, the sentencing judge decided to go easy, quoted as saying, "I am not inclined to subject you to a deportation hearing, but you need to know how lucky you are." Well, no. I mean, the guy has multiple criminal records. We shouldn't be giving him a pass because he might be deported. Let's see. The appeal court, however, found the lower court judge imposed an artificial sentence to prevent him from being deported and raised his total sentence to 13 months and 10 days, acknowledging the punishment will affect his right to appeal and may result in his deportation. His Winnipeg-based lawyer, Edmund Murphy, said it's hard to say whether his client will be deported immediately or not, as he has since been arrested again and is back on custodies of assault with a weapon and uttering threats. So why are we keeping him? Just deport him. He seems to be committing the same crimes over and over again. The Supreme Court of Canada has ruled that judges should consider immigration consequences in sentencing, said Sergio Carras, an immigration lawyer and analyst, but the punishment must still fit the crime. I don't see why they should consider immigration consequences. The punishment should fit the crime, and if those consequences include deportation of non-citizens, so be it. That lawyer is continuing on saying it's unfair, he said, for a non-citizen to get a much lower sentence than a citizen for the same crime. I wholeheartedly agree. So a bit of background that they give here is that it used to be that anyone could appeal a remove order, but in the early 2000s, the law was changed that the right of appeal was denied to those sentenced to more than 2 years. And then it was expanded to anyone sentenced for more than 6 months. Now, while the more than 6 months might seem harsh, if you're a non-citizen and have a criminal record, it's probably going to be real hard to get a job, which means you might end up just being a burden to society anyway. But, I mean, if you've committed a crime that the sentence is more than 2 years in prison, probably don't want you in the country anymore. Like, you know, the guy in the article uttering threats and that. Or the bank robber who got a lower sentence and is being allowed to stay here still. So the Toronto lawyer, Waldman, is saying that I don't think it is unreasonable for Canada to consider taking action against non-citizens who have violated criminal law. I think the changes that were brought in by the former Conservative government were very extreme, Waldman said. That's why you're seeing judges impose sentences of less than 6 months. Well, it's not a right to stay in Canada if you're not a citizen. It's a privilege. And maybe you should keep your nose clean then, if you want to stay here and not commit crimes. Karras said the Harper government changed the rules because some judges previously sentenced non-citizens to 2 years less a day to avoid deportation, which is bloody convenient for the non-citizens, seeing as it's very unlikely a Canadian citizen would have been given such leniency because they're not in danger of deportation. But the deportation is part of a consequence if you are a non-citizen and commit a crime. And there was a public outrage that people with lengthy criminal records weren't being removed for the country. Let's face it, he said, for somebody to be sentenced to 6 months of incarceration, it's got to be a pretty heavy-duty offense. You know, if you're sentenced to prison for 6 months, it's not like this was petty theft. Like Waldman, Murphy believes that anyone should have the right to appeal a deportation order regardless of the length of their sentence. He said Yar's parents support him and want him to be able to stay in the country. Well, if he wanted to stay in the country, maybe he should have stopped repeatedly committing crimes while on probation for other crimes. Like, he seems like a textbook case to toss out. But beyond that, Murphy said cases like this prove that when people immigrate to Canada, they should take steps to become Canadian citizens. Yes, they should. He said it is not uncommon to see people who came to Canada as children lose their status after being convicted of a crime because they never gained citizenship. And they end up getting deported to a country where they are now detached from both language and culture. Well, maybe they should have taken steps to become citizens, and maybe they shouldn't have committed crimes. That's just my 2 cents. Running away from the police and threatening them, that doesn't seem like a hard thing to avoid doing. But hey, what do I know? So what are my 2 cents on this? Well, if you come to a country and want to live there and be there and thrive there, you should adapt to that culture and become a member of that nation. If all you are going to do is come there, not be a citizen, and repeatedly commit crimes, then I don't think you get to live in that country anymore. You've clearly shown an unwillingness to be part of that civil society. Now, should non-citizens be allowed to appeal a deportation decision for crimes that are under a certain length? You know, like, should it be less than 2 years? Maybe, but I mean, it depends on the crime. If it's a one-off event, if it's their first crime and it's not that severe, then, you know what, maybe we should give them some leniency. However, if it's a repeat offender, severe crimes, violent crimes, then deportation just seems sensible. But you know what, that's just my thoughts on things. Hi, thank you for listening. Please like, subscribe, and hit the little bell for notifications. If you're really feeling generous, please feel free to subscribe to the Patreon. If you don't like these things, then don't, and I'll talk to you next time.